Hi, and welcome to the British Law Centre podcast. We are in Dubrovnik at the Inter-University Centre on day 2 of the CEEMC European Law Moot competition, and I'm joined by 2 members of our distinguished judicial panel, Duro Sasa, a judge at the Supreme Court of Croatia and president of the European Association of Judges, and Karsten Zatschler, Senior Counsel at the Bar of Ireland. So welcome and thank you very much for joining us.
Good morning, thank you for having us.
So what I want to ask you about is, last August you filed an application for a direct action at the General Court as a group of judicial associations challenging the implementing decision approving the Polish recovery funds. Yeah? Would you mind describing or telling us a little bit about why judicial associations wanted to commence this action?
The main reason why we did that, and that is something which has never happened before, that judges associations filed such kind of action, and it is for the largest associations in judges associations in Europe. So it's AIJ, my association, MEDEL, Judges for Judges, and Association of Domestic Judges. So we did so because we think that the Poland and the Poland government and parliament are not meeting the milestones and the criteria which have been set up in the decision to reveal funds to Poland. So it is conditional. If they meet these criteria, then the funds are going to be relieved. And as it is not quite clear, is the Council and the Commission going to follow their own decision, and are they going to be firm on that? We filed the suit to stop that until they will reach these criteria. And actually everything is about the independence of judges, and it has a lot of elements. Of course, the independence of judges is a part of the rule of law, but one of the milestones of the rule of law is independence of judges, and it has different aspects. Many of them, they are listed in many documents of the Council of Europe Soft Law, like Recommendation 2010-12, like list from the Venice Commission, like the opinions of the CCGA, and so on. So our standing is that Poland is not doing that, and that there are numerous judgments of the European Court of Human Rights and the European Court saying that and forcing the Poland to change the system, which actually allows appointment of judges who are very close to the recent political powers in Poland. So that's basically.
So then as a novel action, there are going to be procedural issues regarding standing of judicial associations and substantive law issues. Starting with whichever one of those 2 issues, what is the difficulty with judicial organisations getting standing at the General Court?
Well, the traditional hurdle to overcome is, of course, the well-known Plowman test, which requires anybody who brings an action for annulment against an act of the EU institutions to show normally that they're directly and individually concerned. Now, I think here's a good case that the particular act we're talking about is actually something that's called a regulatory act under the post-Lisbon modifications to Article 263, paragraph 4 of the TFEU, so that one doesn't actually need to show individual concern in order to bring an action here. But it's, on the standing side, a lot is going to revolve around the question of, is there direct concern, is this a regulatory act, is there individual concern, does this action require implementing measures? And it gets very quickly into technical language there. I think to cut through all of that technical language, I think there are three bases on which standing in this particular action should relatively clearly be capable of being established. First of all, there is clearly a narrow hard core here, where it's going to be very difficult to deny both direct and individual concern. That is, that there are judges, Polish judges, represented by Justitia, the Polish Association of Judges, which in turn is represented by the European Association of Judges, and these Polish judges are subject to enormous pressures in their day-to-day work in Poland, and a large number of them have been subject to unlawful disciplinary sanctions, which have been held to be unlawful by binding court judgments already. So this is not something that we're merely alleging, there are court judgments saying so. And notwithstanding the fact that these disciplinary sanctions, therefore, have already been held unlawful and should therefore, by virtue of the direct effect of European Union law, be null and void, the EU institutions decided in some of the milestones that were mentioned to, rather than require Poland to recognize that these are null and void and make declarations to that effect, to allow Poland to set up a review procedure and effectively require the judges concerned to run through a new set of applications in front of a new body in order to clear their names, instead of actually having their names cleared by virtue of the judgments that are there already. Now that's an unacceptable additional burden, and it's an unacceptable additional burden imposed by virtue of these milestones, which is clearly of direct individual concern to the individuals concerned. So that's a hard core where I think it's going to be very difficult to deny a standing. There are other bases.
And how do you extend that individual concern of the judges themselves to the association of judges?
First of all, just to say that the reasons why the judges have been found disciplinarily responsible are bizarre. One is because they are sending a preliminary question to the European Court. And it is a well-standing principle that for the decision you cannot be fined liable, or if it is gross negligence or guilt, but that is not the case. Or because they refuse to sit in panel with judges who have been appointed in a system which is found, which is established as a system which doesn't guarantee the independence of judges. Here we have the connection with the Icelandic case. Iceland immediately changed system, went through the review of the decisions and so on. So we have a precedent in the Council of Europe about how to deal with this. So by the statute of International Association of Judges, and European is a part of it, we have a duty, or we took this duty and the role to protect the independence of the judiciary. And that is not something which is abstract, it comes to the individual judge. And we have numerous documents and statements speaking about that. Recently, now unfortunately for Poland and Hungary, but also for Israel and Spain, where we also have this lockdown of appointing the council. So as that, we are representing not association. Association is just giving us the feedback why we should act. So actually when we act, we are protecting judges. And if some of them have a problem because of the system, we are actually protecting them, or trying to raise voice and to make that problem, to bring it to international level.
Because of the systemic nature of the problem?
Obviously, or because of the systemic nature of the problem. And sometimes it is also individual issue. Just to remind you of unfortunate circumstances in Turkey, where it is a long fight with help judges to survive, who have been dismissed, thrown in jail and so on. So we are there just for judges. So we have this I think, legal interest to act in this way. So the lawsuit is one last resort, actually.
And to link to your standing question, and there's a long line of well-established case law saying that representative actions by representative associations in all sorts of other fields are perfectly admissible. An association representing individuals takes the same standing as the individuals it represents. And that's been the case throughout the history of EU law, as in the economic fields, industry associations and so on. There's absolutely no reason that shouldn't apply to judges as well.
But then playing devil's advocate, do you think then the absence of Polish judicial associations in the umbrella organisation that would negatively affect standing in this particular case? That's just a hypothetical, because obviously you do have Justitia and you do represent judges from Poland.
If there would not be Justitia in our membership, then perhaps we would not.
Just from the question of the development of this rule, which allows standing for judicial organisations, European ones.
I was just setting out, of course, the first bases of three
Yes.
bases on which there is standing, but for this narrow part, of course, to the extent that the associations rely on the standing of their members, members who've been subjected to unlawful sanctions, then obviously if it didn't, if these members weren't there, then that basis for standing would go.
Okay.
So then, of course, those judges who are affected with these measures do not oppose. That's how they somehow granted Justitia to go further. And Justitia is not with us because it would be even for them very difficult to actually, speaking frankly, to live in the country, of course, with us. So it is better to have somebody outside of Poland.
Yeah, of course.
This can't be overemphasized. There's a number of the individual judges at the root of this case who very much encourage and ask Justitia to take action, which in turn ask the European Association of Judges and MEDEL, which it's also a member of, to take action. So the individual judges who ask for anonymity as regards their names, and we have, as a consequence, requested that in the documents of the case that has been passed on to the government of Poland, that those names be blacked out, because those individual judges are concerned for their careers and for their livelihoods.
It's incredible.
So I think this is a very good illustration of the fact why this representative action is necessary, particularly in a case like this.
Okay.
And actually, the association is NGO, and we are recognized as NGO in the Council of Europe. And you have in the national legislation also that the NGO can take some class actions for forbidding somebody or something to go in one direction. So if it is in the national levels, it can be on the international. But of course, we cannot do it in Poland because everything is set up.
Yeah, of course. Okay. So that's the first strand. So what then is the second?
Well, I mean, I think we can be relatively brief.
Okay.
The procedural side is probably not going to be the most interesting one for your viewers either. But the second main base that I identify here now for the purpose of the summary of the legal action itself is much more detailed. But the second strand would be that what we're talking about is judges' associations, which are not any sort of industry associations, and the judges don't bring this action, don't become members of these associations as a hobby or as a pastime. They do it in their official capacity. So this is the best thing that we have in Europe, representing the actual interests of that branch of power, that is the judiciary. And normally the judiciary wouldn't be bringing this sort of action, as Duro said at the outset. Judges are reluctant litigators. This is a last resort. Normally it is the other branches of power that should be protecting the weakest one, namely the judiciary. It's because that's not being done in this instance that the judges' associations, as representatives of that branch of power, that branch of government, are bringing this representative action. And we're saying that that being the case, it is not appropriate to judge this by the traditional Plowman criteria, which apply to individuals protecting their personal interests. What is being protected here is not a personal interest of the judges, or not only, but it is an interest of society, an interest in society, in independent judiciary, in a division of powers, branches of government, which are independent from each other. And it's as a last resort that this is being brought, so that it would be wrong to judge us by the Plowman criteria. And then the final strand is I would say, all-out attack on the Plowman criteria in circumstances where what we're talking about is the rule of law being protected. So it's in a way turning this around, the second strand around, looking at what is the value that's being protected as the rule of law, which is part of the very essence of the identity of the European Union. And it is something that all European institutions need to be able to protect. There's nothing in the treaty saying that this sort of action should not be possible to bring. The only thing that we have is case law, the case of Plowman. So it's not a treaty article, it's an interpretation of a treaty article. Interpretations are flexible, and we would say where protection of the rule of law so requires, then a mere interpretation, even if it's a well-established one and one which has lasted us well and has served us well that needs to be revisited, because we can't have an interpretation of a treaty article stand in the way of the protection of the very essence of what the Union is about.
Okay. So,
and also in many constitutions, I think, in the European soft law, the other body which has a duty to protect the independence of judges are the councils. So of course in Poland doesn't apply, but the network of councils of the European Union decided to get rid of the Polish council in that body, in that association. So it is not only associations who should have this role of protecting, but also the councils. But sometimes councils are doing that, something they are not. Somewhere they are not.
So in the absence of a functioning judicial council in Poland, the Association of Judges should be able to step in to protect the rule of law.
Yes.
In whatever forum is available.
It is duty of every citizen, every entity.
Okay. So then that leads quite nicely onto the substantive topic, because you're at the stage where you are preparing for the oral pleadings on the substantive issues, isn't that right?
That's right. Well, we are awaiting actually to be served with the Council's defence on the substance any moment now, well, of course, of next week. We'll also have that. And then the 3rd of May is indeed the deadline. And then we expect a hearing certainly before the summer on both the admissibility of the standing side, but primarily, of course, on the substance. And
but can you tell us, since it's a live case, can you tell us why you think that the implementing decision itself is in breach of EU law?
Well, I think the short way, without preempting what we'll be saying in court, but the essence here is holding the institutions to their own standards. The EU institutions have recognized, and they've said so even in the decision on the Polish RRP, the Recovery and Resilience Plan, that a functioning judicial system, judicial independence, is a necessary precondition for functioning internal control system. An internal control system is, by virtue of the EU legal framework, required in order to disperse funds. Because if you can't be sure that these massive funds, and we're talking about 36 billion euros of European taxpayer money that is going to be spent, if there is no internal control system that makes sure that these funds go into the right pocket, so to speak, to the right objectives, then, as a matter of EU law, this shouldn't be paid. And the EU institutions themselves have made this link between functioning internal control systems and the judicial system. And we are in a situation where there are numerous judgments of the European Court of Justice which have found that judicial protection is not functioning in Poland from lots of different angles. All that we're doing is, by this action ultimately, making sure that the institutions are held to their word, held to their own standard, and that before money is paid out, judicial protection in Poland is re-established, by which we mean that at the very minimum, the existing judgments of the European Court of Justice are complied with. And at the moment, that's not the case. At the moment, I think one of the best examples is that Poland is continuing to this day to pay 500,000 euros per day, rather than comply with an interim measures judgment of the Court of Justice, the Vice President of the Court of Justice. It was 1 million euros per day until recently. Because of partial compliance, that's been reduced to 500,000 euros. But I think it's pretty clear that a country that prefers to pay 500,000 euros a day, rather than comply with judgments of European courts, can't be said to have effective judicial protection in place.
But can we infer from those judgments of the Court of Justice that there is no judicial independence in Poland? Because that hasn't been said in those individual cases. Because then otherwise we wouldn't be able to still apply the LM test, for example, the application of mutual trust in the European arrest warrant.
There were some cases about that.
Yeah, there are cases about that as well. I mean, it's very fortunate in the Court of Justice.
I'm digressing on it.
Yeah, the Court of Justice has stopped short of just effectively pulling the plug on the Polish judicial system.
But that's what your claim will end up eventually.
Well, we don't need to show that there is, there is a question mark to my mind to what extent you can say that there are degrees of independence and the judicial system can be said as different degrees. What you of course have to look at is the judges in each individual case. And as long as you can't guarantee that a politically highly charged case, mainly, about which might have 36 billion euros or at least a large chunk of that at its stake, will have an independent judge adjudicating it, which I think in the current circumstances there can be no guarantees of. In that situation, it can't be said that there's effective judicial protection or effective internal control systems.
Yeah.
That's a short way of putting it.
Because, when we speak about the independence of judges, sometimes it's simplified and saying, okay, judge can be independent if he or she wishes, so it is a matter of character and so on, not to be subject to some influences. So that's fine. And of course, without that side of integrity, it's of course can't work. But another thing, the system has to be created in a way that it supports this value of integrity. So in appointment, in remuneration, tenure, internal independence from the judicial hierarchy and so on and so on. So the judge needs that feeling that the system is behind his integrity. And if you don't have that, then this integrity relies only on the qualities of each person, and that is something which the system, the state cannot rely on that.
Okay, so in a way, like a wider lens view of the case, it's about looking at the national judge. They have no avenue of protecting their rights in national law. They cannot go to a Polish court, but they can if they've already been sanctioned. They cannot make preliminary reference as a judge if there's a question about their independence. And so this is about using all of the available options in European law to allow judges to ensure that their right to independence is protected.
I think the preliminary reference system is a good example that one can sort of pick out as something that is clearly broken in the case of of Poland. Because first of all, indeed, there is a problem for any Polish judge wishing to make a reference in the first case, because judges have been disciplined for doing that in the past, and we still are not clear that they're not going to be disciplined in the future. And I think no Polish judge can really freely avail themselves of the discretion that they have by virtue of Article 267 of the treaty to make a reference. And secondly, even if a Polish court makes a reference, nowadays there are so many so-called neo-judges in place, in function, that the Court of Justice has on a number of occasions come to the conclusion that the courts that have made a reference, because they're not properly composed, are not actually independent tribunals for the purposes of Article 267 1967, so that they actually can't make a reference, and these references are rejected as inadmissible by the European Court of Justice. So second hurdle to references. And then there's a third hurdle, which is that even if a court makes a reference, decides to make a reference, even if that reference happens to be made by old appointed judges and is declared admissible, there's a response to it, well, there can be no guarantee, I'm afraid, that the Polish government will actually abide by the results, and that the individual court will no doubt seek to apply it, but there's no guarantee that on appeal to whatever judicial panel's appeals may lie, the appeal courts, appellate courts, or indeed the Polish government that needs to then implement the decision of the court, will abide by the result of the reference. And I've already referred to blatant examples of Poland not complying with judgments of the Court of Justice. So the reference system in Poland is broken. And that's obviously a hugely important plank of judicial protection and of, therefore, internal control system.
Yeah.
And if I'm not mistaken, the Constitutional Court of Poland declared that the Constitution has supremacy about international treaties. So whatever will come to the Constitutional Court will fail.
Okay.
Well, I think the way many Polish commentators would put this, probably the Polish Constitutional Court has chosen to interpret the Constitution in a way that puts it on a collision course with some essential norms of EU law and international law, and that is a bizarre choice. It's rather bizarre that the Constitutional Court would find out about this years after the accession of Poland to the European Union, because of course these provisions have been applicable in Poland since accession.
And there is also one angle which we should be aware of, that what is going in Poland now is appealing to some governments in Europe.
Yeah.
Regardless are they right or left,
Yeah.
I'm surprised.
There's some media reports about the Israeli government admitting that they had received tips from the Polish government
but
on how to
there's
reform the
also
judiciary.
some where judiciary is used as a scapegoat for everything, and then it is easier to attack judges and judiciary, and then they say, okay, but there are examples how we dealt with this and how we can make it better and so on. So it is something which, if we don't stop it now, it can go to some other countries. And that is also the reason why the European associations had a motive to do so, take this action.
We only have a couple of minutes left, so I really want to ask both of you for your views on Article 2. So that hasn't been mentioned yet, it's kind of like the word Brexit. But obviously Article 2 is very relevant for your claim, and Article 2 is a big topic now with the Commission launching infringement proceedings against Hungary and using Article 2 as a standalone value. What added value does Article 2 give to your case? And also what I want to know is, do you think Article 2 is capable of self-standing application and not in conjunction with some other possibly directly effective aspect of EU law? What are your thoughts on that?
I think the Article 2 is giving a frame for functioning of EU, and there are a lot of parts there and issues which are. One is the rule of law. So when we go to the rule of law, then we can go further on seeing what are the elements of rule of law. And one of the elements, and very strong elements, is the independence of the judiciary. So Article 2 can be interpreted in a way that these milestones are reached if they don't comply with the standards, which are mostly in the soft law, but this soft law is also a result of common thinking of many players, and so it is the best what Europe can give in this area. So I would not be so, we will not just, how to say, to put it aside because it is not completely written in the law.
Yeah.
And the European Court of Human Rights has relied on many of those soft law documents when arguing decisions, especially when the judiciary is in place.
to my mind, Article 2 is quite hard law. It's the very identity of the European Union that's described in Article 2. Very fortunately, the cases are very rare when one will have to rely on Article 2 itself, because hopefully member states are seen as a precondition of accession to the European Union, that there is compliance with Article 2. Very fortunately, it's going to be very rare that member states are going to be at odds with that. But I think it would be wrong to say that only the Article 7 procedure, which has been described as the nuclear procedure, is the only way of safeguarding values which are so much at the core of the European project. And I think it's pretty clear also from the judgments concerning Hungary and Poland concerning the conditionality mechanism, that EU institutions are required to ensure safeguarding of the Article 2 values in every aspect of their action. So I certainly think that Article 2, exactly as Dura said, should inform all the actions of the European Union, but also see by the same token that it ought to be actionable in itself when required.
And what added value do you think that would bring to any particular case? Just speaking randomly. Because a lot of the values that are enshrined in Article 2, and they represent the identity of the EU, but they are also represented in other parts of the treaties. So even in the Commission Hungary case, which was challenging the education legislation on banning children from viewing homosexual activity and stuff like that, there's the Charter, which contains similar rights to what may be used from Article 2, but the Commission is using that as a standalone action.
You're quite right that Article 2 has many concretizations, and as regards to judicial independence, of course, we've got Article 19, for example. But I still think that, certainly if you think of Article 2 as the entry ticket to the EU itself, as the Copenhagen criteria concretized, that there's added force to that, because in the background, I think for very good reasons nobody wants to say it, but a state that doesn't comply with Article 2 anymore has no business being in the European Union in the first place.
So if they had reached Article 2, they would have reduced the standard they had when they entered the EU.
That's it.
The Republican rule.
The Republican rule, absolutely, and the rule against regression.
Yeah, and all citizens of the European Union are relying that every country will go along this Article 2. So when we are traveling somewhere, we would like to feel that it is the case. So that is, again, we come around to the individual citizens.
That is fantastic. I just want to say thank you very much. I enjoyed that. I know our students and viewers will also enjoy watching this video. So thank you so much for joining me today. Enjoy the rest of your day at the CEMC.
Rory, have a good time in Dubrovnik. It's always a pleasure.
Yeah, enjoy it. Yeah, I'm leaving. I have to go to Zagreb, so I will go a little bit earlier because of this soccer game in the afternoon, and I think it will be packed.
We'll cut that bit out.
Yeah.